All right, this is LAWS12059 Conveyancing, and this is the last tutorial. Lucky last on topic 11 on options, and of course we would end the process on something easy and light and straightforward, like options to purchase and rights of preemption, wouldn't we? Any comment on that, Grant?
I think it was, well, touch wood, I think it was a relatively easy topic to finish on.
Yeah.
But admittedly, towards the end of the course, though, when everything is colliding together, the time that gets spent on that last week's material is probably a lot less than other weeks.
Well, that's right. That's right. But you're, let me just say, you, David, who's not with us, has also made a contribution to the posting responses to the questions of this last topic, and both of you doing that, appreciated, and I gave you some feedback on your responses. Yes, that's true. I think the topic is not, as it stands, usually demanding. Going forward, I might try and expand it out a bit more on the basis of the material in the text. It's not a, yeah, I agree with the observation you've made. I think there's more there that could probably be teased out if I have another look at it when the course is offered next time. It won't be offered again until 2016. You've got in before it goes off the boil for a while, because it's only going to be offered every year about from the end of this term. Yeah, so basically the topic is looking at, on the one hand, these things called rights of preemption, and then on the other hand, the option to purchase. And the questions are trying to tease out the dimensions of these things, the not necessarily straightforward nature of what they are and how we understand them, and the case law that informs that, and the different categories of options to purchase. The differentiation between the contractual nature of the right of preemption on the one hand and the proprietary interest which the option generates. We've seen, of course, this idea of the option to purchase before, which you may have noted, when and it comes up very typically in a practical context. We didn't do it in this course, but in land law, when we looked at leases, you might recall that sometimes there's not only an option to renew the lease, but sometimes there's also an option to purchase, which is something quite different, of course. But it was raised in that context, and it's not atypical that it comes up in that situation in practical commercial environments. A little bit sort of, in terms of those categories of options, the put option, the put and call option, the call option, just, getting our head around that. And also the issue about time, again, the insistence on time requirements and meeting time requirements, where that's specified, and it's absolutely, even to the hour, if that's specified as well, which is noted in the notes. All right, so with that sort of bit of overview, would you like to launch us off with the first of the problems, problem 24?
All right.
Sure, it was
24, explain how a right of preemption is different from an option to purchase. Without reading verbatim, my response, essentially a right of preemption is a contractual obligation that if the seller is going to sell their property, that they give the right of first refusal to the buyer or to the. I'm just trying to think in the context now. Because now I am thinking about the leases and the options in the leases.
I knew you would be. I knew you would be.
I was about to say the lessee.
Yes.
So, well, in this case, it could be a lessee, I guess. Although, under these circumstances, it may be a completely independent party that has an interest in the property. That if it comes up for sale,
yep,
they want an option to buy that property,
yep.
And that's the right of preemption. It's just that if they're going to sell it, then that's the trigger, and they are obliged contractually to go to that person and say to them, I'm selling it, here's your chance, do you want to buy it? And then they have a contractual obligation to either proceed with it or reject it. And once they reject it, it's lost forever.
That's right. The characterising this right of preemption as a right of first refusal, and therefore it's basically saying, if we boil it down into fairly plain language, it's like you're the first cab that's going to be made. It'll be offered to you first before anyone else, basically. Yeah. And you have the right to say no, and then we won't go on to someone else until we discuss it with you first. Right? Just wanted to explore a little bit this idea that the contractual nature of the right of preemption. What do you think? Is there any role for equity in this area?
Not at the initial stage, because it doesn't attach to the land, because there isn't an interest per se. Actually, I'm trying to understand.
No, I wasn't thinking about. Sorry. I think you might have. What I meant was for a court of equity, in terms of the fact that we're looking at something that's contractual, and therefore there's promissory in character with regard to the nature of the right. What I'm just wondering if you want to comment on what you think a court of equity's response here would be with regard to seeking to enforce that promissory character of the right.
Well, that would be enforced as, under contract law, it would be enforced. In a court of equity, it would be if it was unconscionable for the seller not to give that first right of refusal, then I would say in equity they could be stopped from denying that right and essentially being forced to give them that option.
Of course, very typically, equity intervenes by use of a mechanism like estoppel, for instance, promissory estoppel, where for whatever reason you can't rely on the contract and you can't enforce obligations under the contract because for some reason you're not able to do that. It's maybe non-compliant with some form requirement, whatever. It's not enforceable. Yeah. How would that work in this situation?
Making me think. Well, if for example, if there was no consideration, because if it's a contractual obligation, well, really there would have to be some type of consideration for them to be bound. So I'm just trying to think of an example as to why equity would intervene. So but this sort of comes back to the estoppel, because if the seller had led the other party to believe that they would proceed with it irrespective of whether there was consideration or something like that, that just brings me back to estoppel again. So
yeah. Sorry, go on. Yeah, sorry.
I'm not sure. I'm not sure what direction you're looking to take this. So.
Well, the point here is that estoppel, of course, is grounded in the conduct of the party. We come back to this issue of the conduct of the parties, right? So what I'm sort of trying to get you to think about is that if, in fact, the parties are trying to get out of what they've promised that's with respect to a right of preemption, then it might be that equity will intervene to enforce the promise where there might be some other issues or problems with using common law. See, the right of preemption, is contractual in nature. It not necessarily the case means that in every situation we might have something that we can enforce contractually, but we might be able to use other mechanisms of law to enforce the promises that have been made, and which it would be inequitable to allow the promisor to resile from. And that's where this idea, the estoppel idea comes into play, all right? Promissory estoppel, of course, in the Australian context. It's just that, I'm just throwing it up there as a bit of a variation on the theme in terms of how the person that has the entitlement to the right of preemption can enforce that if there are some problems or issues with seeking to pursue the contractual basis. It just is interesting, I think, that you have to look at, as a lawyer, particularly, thinking in practical ways and pragmatic ways, you're always looking for how can the law be utilised to achieve the aim that my client wants. Clearly, if I'm acting for the party that has the benefit of the right of preemption, then I'm trying to find a way to make sure the party that's offering, has the obligation or has promised to offer that, does so and isn't able to escape from that. And if there's some issues or problems that mean that maybe general law can't be utilised, can I revert back to equity? You always have to be. I think the point here is, and of course there's some involvement of legislation as well, Property Law Act in terms of the time duration issue of those sort of rights, but we can't ever forget that there are these three sources, I should put it in quotes, potential sources of law that can be used for the purpose of securing rights and obligations between those that are brought into a legal relationship. And don't ever get too tunnelled in one direction. I think, in the interesting thing about the law, the legal frameworks that govern land transactions, land contracts, and even in this topic, is that we've got the general law, we've got legislation, and of course we've got outside of this situation the contract of sale. We just need to remind ourselves about that all the time. That's really all I'm getting at. And also, think of or reflect upon creative ways and interesting ways within which the law can be brought in aid of marshalling an argument for the party that you're representing. And don't forget that the law is not a closed book. It continues to evolve in response to changing circumstances and conditions and changing ways in which individuals and business entities and corporations are trying to achieve their aims and objectives. So that's just...
A right to preemption, because it is not an equitable interest in land, therefore that you would not be able to caveat on a right of preemption, would you?
No, no, no. Of course not. Of course not. There's no, because it doesn't. It doesn't. It's not about a proprietary interest. You see?
Yeah.
It's contractual in nature. So therefore, and this is why what I was trying to toss out a bit, left field, as I tend to do sometimes, is, well, all right, it's contractual. What happens if there's some problems with the contractual structure, if you like, of how the right exists? Can we go to anything else to enforce what underlies that? And what underlies anything that's contractual is its essentially promissory character. And the law will always try and find ways to keep people to their bargains and keep people to their promises unless there are good reasons not to do so. So again, this takes us back to this first principles approach. You can see the language that I'm using there. I'm not using the compartmentalised language of law, but I'm looking more organically at the problem and saying, well, what's going on here? What's the nature of what's going on here? How can I use law and various legal mechanisms that have been developed to try and allow the party to achieve what they want? The beneficiary, if I can use that sort of way of putting it, of the right of preemption wants precisely that. It doesn't want that right of preemption to fall over and not have it. So if there are problems with the enforcing of that right against the party that's promised to do so, what aspects of law can be utilised to try and require it? That's the one I'm getting to.
Yeah.
All right. Well, that's fine. Okay. Let's just done all that. Rights of preemption stage. Do you want to just say just a couple of things about the stages?
The 4 stages. You have the grant. That's the contractual right of preemption. There is going to be an event that triggers the obligation for the seller or the owner of the property to offer the property for sale. And that's also the point that it does become an equitable interest in land. The 3rd stage is the period of time that the grantee has to accept or reject the offer. And then the final stage is either the acceptance or rejection of the offer.
Yep. 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 Yeah, that's fine. That's fine. Just a couple of points there. One is the triggering event, as I note in my notes at page 8 or 9. It can be sometimes a little bit contentious. What is the triggering event? And just need to, have care and concern with regard to that. And then also the point before that you were adverting to with regard to the equitable interest and then equity stepping in to protect the equitable interest. And of course that raises the point that I was getting at earlier in terms of equity's involvement. Of course, it doesn't always necessarily need to have an equitable interest for equity to be involved, but that's certainly the right can emerge into an equitable interest, and at that point, then of course the full array of remedies that equity can provide will be relevant.
And that would be the point at which a prudent purchaser, if they knew that they wanted to proceed with it when the option became available, that would be the point at which they would caveat to make sure that they can then protect that interest, wouldn't they?
Well, that's right. That's right. So the interesting thing, of course, is though that there's likely to be contention as to whether we have an equitable interest or not. That's so that's
is a mere offer to say, I will offer to sell you the property, but we still have to agree on the terms and and whatever the case may be, at what point does that offer become a legitimate interest? That's,
exactly.
I guess, the point.
That's right. That's precisely right. And there will be argument about that. Now, the interesting thing about caveating to protect an interest under the LTA is, of course, the registrar will have to be satisfied that what is had by the caveator is a caveatable interest, and they will look at what is being asserted to be in existence at that point, particularly in this context, to trigger that mechanism of protection under the LTA. Yep. All right. Okay, that's all right. Let's move on to the next question on options to purchase.
Explain the different types of options to purchase. And I'm just going to quickly read the next one so I don't have to go back into it.
Yep.
And with reference to case law, discuss the competing explanations of options to purchase which have emerged. So the options, there are three types of options. There's the call option, which is basically the grantee or the buyer. That's their option that they can call to compel the owner of the property to sell the property to them and to convey title or to effect a transfer. A put option is where the owner of the property can compel the optionee, the grantee, to buy the property, that they have to accept a conveyance.
Yep.
And the third is really just a combination of the two, which, if I've understood this correctly, usually it would be the person with the call option, the buyer,
yep,
grantee, who, if they don't exercise their right within a given time frame, then that triggers a right on the owner to exercise, if they want to exercise their put option to force the grantee to buy the property and accept a conveyance.
Yep. Yep. No, that's good. Yep, that's good. And yeah, I mean, just those three categories and explaining how they work and how they function, how they're different. Yep. No, that's fine. The second part, can you just focus on that recent case you've referred to in your response, the David Dean decision? I think that's a bit more interesting than the earlier cases.
Yeah, bear with me a sec. Oh, okay. Just before I get to it, though, this actually goes back to something that we touched on before about condition precedent and condition subsequent.
Yep.
That the modern interpretation is similar to the argument that we had before, that whether it's a condition precedent or not becomes quite irrelevant, because there is an argument you can construe virtually any condition to say that, well, if there's a meeting of the minds, a contract is formed, there is a conditional contract, so therefore any condition becomes essentially a condition subsequent to the formation of that contract.
That's
and
right.
that from that case, that I think was the underlying interpretation, is that having an option to purchase, provided that there is an exchange of consideration, that's the formation of the contract. So then, now I'm just trying to put this back in context. So the contract of sale is formed on the conditional, well, it's formed as a condition subsequent to the buyer exercising their right to compel the seller to convey the land.
Yeah. Yeah. And I think that point, you didn't actually tease that out in your response, but that's fair enough. Time constraints and other things taking one's time, I suppose. What you've teased out there in your verbal response of the more modern understanding as opposed to former classification or the former approach that sought to classify into certain categories. I think that's really important. You know, we've touched on this before, as you mentioned. And sorry,
this comes down to the intent of the parties. What's their intent?
Absolutely. And you know, I think, you know, what happens in the law. It happens quite a bit actually, unfortunately, is that you get, you know, as a consequence of litigation, you get disputation arising, and you get then, you know, decisions being handed down, and in an attempt to logically and systematically explain how we should understand things and how we should separate things to give them a sense of internal logic, judges will often create, you know, categories, label things, but those labels are not intended to be rigid boxes that things are slotted into with no other variation on the theme. The problem that happens is that people find, you know, lawyers and subsequently those looking at this find it convenient then say, oh, right, there's a category, does it fit into this category? And then over time, it tends to become a bit rigid and a bit solidified, which is, you know, a bit partly induced by the common law precedential method. And then, unfortunately, what we end up with is something that's quite artificial. So we're worrying and fretting over these categories. Does it fit into this category? Does it meet the elements of this category? Does it? Well, that's not what we should be about. What we should be about is focusing on in my view, more organically upon what is it that the parties are doing here? What are they trying to achieve? By what process or method? What is their intention? What can we look to examine that intention? And how should we best understand that in terms of what the law requires or the law demands from this? So that is, you know, the more modern view. Thank goodness we've reached that point. And so going back to old, more stylised classifications or categories, I don't think personally is necessarily helpful. We can use it, you know, obviously there as a guide, but we need to more fundamentally examine what parties are trying to do and how we best understand whether they can or can't do that against what the law permits and doesn't permit, and why it permits and doesn't permit in certain areas of interrelationship and legal relationship in familial, personal or business situations. So, and I think that, as you've indicated in what you've said, but not necessarily, that's why I wanted to tease it out a bit more from the written response that you'd posted, because I suspected that's what you were getting at, but you needed a bit more fleshing out of that. So I think, you know, therefore we come to that way of approaching how we understand the competing explanations have emerged over time, where what we find now, the more modern approach, is to, you know, fundamentally focus on what the parties are trying to achieve, what their intentions are, and then has that, you know, is what they are doing here, is it effectively achieving that, and is it an option to purchase, and what's the how is that functioning and achieving what the law requires in that area. Right. Anything more that you want to say?
Not really, just one observation though. Goldsborough Morton Co.
Yeah.
That's a 1910 High Court case, recognising that an option to purchase is a conditional contract of sale.
Mm.
And that is sort of what is being accepted as the modern view, and yet it was 20 odd years later, nearly 30 years. Oh, sorry, no. What was it? Yeah, 27 years later, that Commissioner of Taxes versus Camphon that had that opposing view that viewed it as a separate contract. So it seems like, without sort of seeing what has happened in the middle there, does that mean that that was an accepted view, it changed, and now it has changed back? Or
I think there's the best way to put it is a waxing and waning here.
Yeah.
The option to purchase is a bit of an unruly beast, and it's not necessarily easily pigeonholed, and that's why I think you've got to focus very carefully on the intention of the parties and how we best explain it. Yeah, I mean, you've got those competing views, and I just think the best way to put it is that there has been contention, and there's been a bit of a waxing and waning, as you mentioned, and it's good by the way, to always encourage students to do this, to look at the historical evolution. So quite rightly, you're pointing out there we've got a case emerging in 1910, 1937, 20-year elapse. Then we've got the David Dean case in 2005, and yes, there's gaps there of decades, but we've got that waxing and waning in terms of how we best understand the option to purchase. The other thing too, Grant, never forget the historical milieu within which the law is evolving, it's not entire, it's not without moment, put it like that. I'm not saying it necessarily is always bearing entirely upon the dispute at hand, but it's not without moment to historically contextualise what's going on. Roughly around about 1910, and what was the situation and the circumstances of commercial life and transactions with regard to land at the turn of the century, just after Federation, etc. And then, in the 1937, leading up to the outbreak of the Second World War, for example, and then, into the more modern period in 2005. And whilst those historical factors, as I said, are not necessarily bearing down on the particular dispute between the parties, it's invariable that disputes and transactions and then disputes arise out of the historical environment within which they take place. So I just think it behoves us as scholars and students of law to be mindful of that. I think sometimes that's forgotten. We just become overly clinical in our focus on the rules and the principles which have emerged, and we forget that they come out of a context, they come out of an environment. I'm going to say something here which is totally left field, right? Has nothing to do with land transactions or land contracts or options to purchase, but it reminds me of something that I heard recently again. I've seen it a few times, or viewed it a few times. There is a very interesting, and it's interesting because it's one of the very few instances we have of this. We have a recording of the argument before the High Court in the constitutional case of Catanari and the Commonwealth. Have you seen that, by the way?
No.
Okay. it's fascinating because the bench is comprised of Brennan and others, but also Michael Kirby, a great reformist judge, and the counsel for Catanari was who was to become subsequently the Chief Justice of New South Wales, Jim Spiegelman, and counsel for the Commonwealth was Dr. Gavin Griffiths. And just it's not a huge clip actually, it's about maybe 20 minutes. But one of the things that emerges is that that case was about the Commonwealth trying to do something by using the race power in the Constitution. And Kirby responded to one of the points that was made by the Commonwealth by saying, I can't possibly believe that the language used in the Constitution in 1900 is set in concrete in terms of the social milieu and the bias and prejudice which existed at that time when those words were drafted. We cannot conceivably continue to hold such positions in the interpretation of language which constitutes law today. Surely that's true. That's the case, isn't it? And Gavin Griffiths navigated around that a little bit, tried to, not very successfully in my view. But it's really, in my view, really telling point that it doesn't matter what we're talking about, whether it's the Constitution, Australian Constitution, or whether it's an option to purchase, or whether it's a contract of sale. The context is fundamentally and crucially important. When we're looking at the law, the case law, we do need to have an eye to the historical milieu out of which that law emerged. And that's why law evolves and changes, and must, because the milieu and the social circumstances and conditions do not remain the same. So just as we find in our area, that compartmentalisation in contract between conditions, subsequent conditions, precedent no longer carries the same authority as it once did. This is true in all areas of law. And as both a student of law and subsequently a practitioner of law, that's really important. It's really important to have that breadth of perspective in how to think about how law is impacting upon a situation and responding to that, and how we need to approach it.
Well, I guess you only have to look at the Torrens system and the development of land tenure and leases and native title. In that sort of context, it is very much a product of environmental influences that, so I take your point. Absolutely right,
absolutely right. And we must never retreat back into what I call the clinician's defence, that it's just about a very clinical exercise of rules and principles and slotting them into the right slot, and that's where we get the outcome. Law is not like that at all. And that's what actually makes law both challenging and fascinating, because it's a moving feast, and it's about that array of rules and principles that have emerged and developed over time, but it's also about how that framework and fabric is responding to the evolving conditions that it's relevant to. And this is probably, an appropriate point to sort of pull things together, if you like, and I'll make some observations about the final assessment too. In my course, that is. It's inescapable. I'll put it like this. It's inescapable that the practitioner of law going forward into when you finish your studies and become a practitioner is going to be quite different to what I experience as a practitioner, and indeed I believe what is even currently experienced by practitioners. And the enormous change that technology and e-technology is bringing upon us in our professional lives as lawyers and practitioners has to be embraced. And in this topic, this subject area that we've covered in this course of conveyancing, we've seen how it's having significant impact and how we have to keep responding to those changes and adapting to those changes. The law has to respond as well. It has done so through changes, through enactment of legislation, through amendment of other existing legislation, but it's going to have its significant effect on practice and habit, behaviour and communication between practitioners and clients, between practitioners and between practitioners and the wider community. And there is both opportunities and challenges there. We have to rise to the occasion, but we also have to see how the framework of law that we have and the framework of regulation that we have, which in the area of conveyancing governed by contract of sale, the legislative structure or framework, and the body of case law needs to work with this fast-moving and evolving landscape in which conveyancing will be taking place. And that's, something we have to appreciate. And then the undercarriage of that, which is featured often and prominently in our discussions and noted, I think, by yourself on occasion, is the significance of ethics in the practice of law and for the practitioner involved in the facilitation of conveyances. E-technology brings further challenges in this regard, and the interconnection between ethical obligations and ethical duties in the e-environment has to be further reflected upon. And I personally believe that the current ethical rules that govern practitioners has been developed adequately to understand those challenges. In speaking to lawyers in different situations over recent months and giving some presentations, it's patently clear to me that even though we now have a set of national rules governing the practice of lawyers from an ethical perspective and more generally conduct rules, some of them have not anticipated, in my view, the implications of e-technology in terms of how things will be done differently and the consequences of that. And that's something yet to be fully tackled, I think, but I'm no doubt that it will be in various ways. So in this course, we've traversed through the conveyance transaction. We've looked at the various pieces, various steps and stages along the way, from the early steps through the negotiation, through the formation of the contract, through the various features and aspects of the contract, the subject matter of the contract, through to completion, and then remedies, and then lastly, in terms of this a bit more contentious area of options to purchase and rights of preemption. Don't forget that there are three types of standard form contracts of sale in Queensland. There is the houses and land contract, essentially for residential transactions involving freestanding dwellings. There's the contract essentially for BCCM type scenarios, and then there is the commercial contract. Don't forget also that as a practitioner, one can act for either a vendor or a purchaser. Don't presume that scenarios that one may be presented with will necessarily come from only one perspective, because how we function as a practitioner in representing either the vendor or the purchaser brings different issues and different challenges. Now, with regard to final assessment and conveyancing, you've got the instructions for that. You know that you're going to, it's comprised, it's a 60% final. There are 2 problem-solving questions which will be worth 20 marks each, and no options there in terms of, well, no choices with regard to questions, but 2 questions and required to answer both. And they will explore the, the ideas, the elements of the process that we've been examining in the course. It's hard for me to say, I don't know if anyone in this course has done it. As a landlord, I've had 1 or 2 students say, oh, what topics? Sometimes hard to say it's just a set topic in this area, because it traverses the process and it can pick up on bits from different aspects. So, you're best encouraged to think about the process and to think about, go back and have a look at, what sort of strategy was adopted in the quizzes, the style of questions, and also in the tutorial problems, will not be dissimilar, but obviously, the problem scenarios in the final will be more extended, and you'll have to do 2 of those. And you could be asked to advise the vendor or the purchaser. You could be asked to explore various aspects of that transaction in different ways. So just need to anticipate that. That's in part B. Part A is, as the instructions indicate, there's going to be 2 questions and you'll choose 1 from 2, and they'll be discussion type questions, and they will be getting you to think and explore some of these broader ideas and these broader themes that I toss up, and have repeatedly tossed up throughout the course, through the classes, in my material, and which we've talked about and debated in various ways in the tutorials. The final assessment will open on Monday, week 13, and will be due for submission on Wednesday evening of week 13. And I will create a submission portal on Moodle for you to submit your final assessment documents either in PDF or Word format, and then they'll be re-uploaded through Moodle when they're graded ultimately, and you can get access to those following the finalisation of the grade process. Any questions?
Not specifically. One observation, which I hope is not inappropriate, is for students with children. The school holidays have started, so it's already school holidays this week and next week. I'm pretty sure, I think Brisbane's on the same schedule as New South Wales. If there was any option to have the Sunday on the weekend to be able to spend some time on this, because there will be certain weekdays that are going to be quite difficult.
Yes. Okay.
I just wanted to.
Yep.
I just wanted to. And same in terms of land law, that again with the weekdays, which are particularly challenging because if partners are at work and it's around, having, for example, the Saturday. In actual fact, for me, if that was a viable option, probably a very big portion of the work I would do on these assignments would actually be on the Sunday for conveyancing and the Saturday for land law.
Yeah.
So it was just, and I hope that, obviously I'm only one student. I would presume that there will be other students in a similar situation, but not all students. That may help some, it may not, I'm not sure, but I just wanted to mention it for consideration, that's all.
Okay. I'll just, I'll take that on board, Grant, and thanks for that. What I might do is I'll just wrap up and then I'll stop the recording and then we can maybe talk a little bit more about that. Is that okay?
Yeah, for sure.
Yeah. So, okay, so that's the end of the course. If there's any further advice that I'm going to make about the timing of the final assessment, just in light of Grant's observations, I'll do that via email to students, okay? But can I just say in this final, as this is the last class, can I just say that I have really appreciated the involvement of those that have come to class. That's yourself, Grant, Lisa, who I know currently is travelling, but before that she was very consistent in attending. David, who came to several of the classes. Unfortunately, Tijan, I think work commitments prevented her from attending. But look, it's really important to be involved in class and to be challenged and provoked by that. I've certainly appreciated the comments and the exchanges. It's just as important from my side of the table as is, I hope, from your side of the table in our learning of the law. And it's something with online learning, and we are rather in a unique situation here at CQU, having an entirely online law degree. We don't have too many others in the country doing that. And we have people watching us, you know, in terms of are we hitting all the marks, in terms of adequately preparing our students for the rigours of law practice and so on and so forth. I believe that we are. I believe I'm doing all that I feel that I can do for that. But this sort of interaction and involvement in class is important. So I just want to say that and I want to thank you for that. And look, I hope, you know, the course has been beneficial, useful, and that you've enjoyed the course. Certainly if, again, just as a last point, if you haven't completed evaluations, if you can do that, that's greatly appreciated. I certainly value that feedback, as does the system. And also just to remind everyone that there is also national evaluations currently on foot as well. And if you've received any information about that, if you have the chance to be involved in it, that's important for the university, because that information then gets fed through to good university guides and other documents which are important for our standing in the higher education sector, and also you know, just in terms of how the broader environment of students perceive what we do. So, look, I've enjoyed the course. I've enjoyed involvement in the class with those that have come, and I just want to finish by saying good luck with the final assessment, and good luck with the rest of your studies in your law degree. So, bye for now.
Thank you, Michael.
I'll just stop the recording.
I just wanted to...
Now, say, you want to say something? Yes, please.
I've appreciated the tutorial, and I've enjoyed the tutorials, and I've enjoyed the fact that you have been challenging and you tackle issues that require sort of deeper thinking. It's sort of yeah, I've thoroughly enjoyed it. So thank you for that.
That's right. It's my pleasure, because that's what I believe legal education should be about and needs to be about. So I'm going to sign off now. I'm going to stop the recording, and then we can just maybe have a bit more of a brief chat on that other matter. So bye for now, and all the best for all those in conveyancing with the final assessment.